Well, while the panel are admiring their pictures on the wall, I think we can kick off. Good afternoon, everyone. End of a tiring day. You must be exhausted. But you're about to be stimulated by the sparkling intellect of this heavyweight group on the panel. So I'm going to start by introducing the distinguished speakers. Very briefly, because their bios are on the website. In alphabetical order, Theodore Christakis is the Professor of Law at University Grenoble-Alpes and the Director of Research for Europe with the Cross-Border Data Forum. He has written humongous amounts about Privacy Shield, Schrems II, and now the DPF. And most recently, I'm sure you're aware, he's done this huge report about what he regards as the zero risk fallacy pursued by data protection authorities. Dr. Laura Drexler, the far end, is assistant professor at KU Leuven and a researcher for the Belgian State Archives on the intersection of data protection law with data law from a human rights perspective. She is an author and assistant editor of the OUP GDPR commentary, and I believe that she's perhaps the only person who's read all 1,400 pages of it. She's written a very interesting chapter on the subject today with Irene Kamara on essential equivalence as a benchmark for international data transfers. Dr. Nora Nilejian is director of the Information Law and Policy Center at the Institute of Advanced Legal Studies in London. She is now joint editor-in-chief of the IDPL following the resignation of Chris Kuna, and she's an author of the forthcoming second edition of the OUP commentary on the GDPR. She's written about the case law of the Court of Justice and the Court of Human Rights and UK adequacy after Brexit. And her latest work is forthcoming data privacy law and serious crime, and it's going to be very good because I've read a chapter of it. And then last but not least is Professor Peter Swire, who's the Holder Chair of Law and Ethics at the Georgia Tech School of Cybersecurity and Privacy. For his sins, because he studied at ULB, he's become one of the greatest American experts on EU data protection law. He was the first White House privacy czar. Is there anybody else, except for Peter and me, who was involved in the safe harbor negotiations? Is there anybody that old? No. Well, anyway, long time ago. Some of you may have been at the CEPS panel that reported on their report today, which took place just after lunch, and I could recommend you to read that. It's the CEPS Task Force report on reconstitutionalizing privacy, and it sets out from one point of view, the issues we're going to discuss today. There is so much to discuss, so many possible points. We've had to choose. So the panelists have been asked to focus on the strongest and weakest points that could either strike down or uphold the data privacy framework in a challenge before the Court of Justice. And this means, and I'm glad to see they brought that out at the CEPS panel as well, two themes: proportionality, which will be Nora and Theodore talking about it, and judicial redress, which will be handled by Laura and Peter. And we've timed it. They promised to stick to 8 minutes for their presentations. We've timed it so that you will have time for questions. You may think that we have not covered something, so ask your question, and then we can discuss it with the panel. We've made time for it. Before kicking off, just let me set the scene, at least from my point of view. I'd like you to look at this discussion with a very particular vision. And while you're listening to the speakers, ask yourselves this question: what do we want as EU citizens from third states concerning government access to our personal data exported from the EU? What is it we want from not just the US, but everywhere? Because, of course, this is not a problem unique to the US. If we accept the EU organizations, I mean, companies, organizations, whatever, in the EU need to send personal data abroad lawfully, then we need a means and a standard that makes it possible for them to do so. There's lots of means under the GDPR, adequacy, standard contractual clauses, BCRs, certification, you name it. We're not short of means. But after Schrems II, each and every one of these means is subject to the standard that the receiving state must ensure an essentially equivalent level of protection to that here in the EU. And in particular, this must be an essentially equivalent respect for our fundamental rights in the Charter of privacy, data protection, and judicial redress. The Court of Justice requires the EU to walk a fine line. The data protection the standard must be high, but it must also be possible. It must be possible for third countries to achieve, within their own constitutional frameworks, the ability to receive personal data from us. Another question, what if a third country, with its own constitutions and its legal and administrative systems, respects the international standards on government access? We have lots of standards now which we can look at. 2021, the Global Privacy Assembly resolution on standards for government access. 2022, OECD declaration. Are these standards enough for us in the EU? So please try and look at the DPF from this perspective. Is the DPF something that we might actually want? Could it serve as an example of what a third state could do with regard to its intelligence agencies and their law and practice, which essentially respects our fundamental rights standards? The DPF is miles better than the Privacy Shield. Of course, that's not necessarily saying very much because the Privacy Shield was fatally flawed, and even the Privacy Shield was better than the Safe Harbor. So if you're a cynic sitting here today, you may believe that every time that the Court of Justice has struck down a deal, the US has managed to do better. And it should do so, and the US can do better again. If you're a principled pragmatist, you may agree with the European Data Protection Board, which says that a lot will depend on how the US authorities implement the DPF. And they want to read about that in the reports by the PCLOB, Privacy and Civil Liberties Oversight Board, which they trust. Or you may be a purist, and you may rely on the Court of Justice judges having an agenda to make the world a better place, or at least a place with standards that look more like ours. Have no doubt, President Lennertz and Rapporteur von Danwitz have both made such statements. They want to make sure that our data is exported respecting our fundamental rights standards. The trouble is, there is a huge problem of legal uncertainty at the moment, not least because of internal inconsistency here in the EU, inconsistency between the Court of Justice, the Court of Human Rights. We really need to put an end to this. So maybe we should see a challenge to the DPF as an opportunity. Give the Court of Justice the chance to hand down a clear judgment, bringing together the rulings on transfers. And either they will take a holistic approach, as already taken by the Court of Human Rights, and analyze whether the DPF taken as a whole, with all its checks and balances, is enough, or they will take a very specific fundamental rights approach and concentrate on the weaknesses. But then you may ask yourselves, if they do that, this may, or should probably, open up challenges to other adequacy decisions, such as the UK, Israel, Canada, to name but a few. So I ask you, when you're listening to the speakers, try and think like one of the Court of Justice judges who will be thinking about all this. What will you think? What will they think as a result of the discussion? Will they think, job done? We've finally got an acceptable result. Nothing is perfect in this naughty world, but it's acceptable. Or will they think, we're not sure, we have doubts, but we'll give it a chance to see how it works in practice, and when we get the next reference, we will then handle it. Or will they just say, nope, not good enough, try again. So with that, I'm going to start the discussion. Could we have the slides for speaker number 1, please? Great, you're away.
Thanks a lot, and many thanks to, first of all, to Georgia Tech for organizing this panel, and to Chris for these fantastic introductory remarks. So I have not 8 minutes, but 10 minutes, as we agreed, Mr. Chairman, like all the others also. And I have, as you, Chris said, Nora and me will talk about the toughest issues, which is the proportionality, and then we leave the easy things to Laura and Peter. As a matter of fact, I do believe this in the way from Schrems II to here. You know, all my US colleagues were saying, oh, the hardest issue is redress. No, the hardest issue for me is clearly proportionality. And I still believe this. And of course, it's entirely impossible in 10 minutes, now 9:10, to be able to address all these issues. I would need 10 hours to discuss proportionality in the new data protection framework. So I apologize for this, but I only picked 3 issues. I am entirely at your disposal to discuss anything else. Chris sent an email with very interesting additional questions. I would be happy if we have the time. But my first remark is, what are we talking about? Between Schrems II and today, we're always saying, you know, we're using a raccourci, a shortcut, saying we have on the one hand proportionality, on the other hand redress. Things are much more complicated than this. And as a matter of fact, behind what we call the proportionality problem in Schrems II, in reality, what we have is something much more complicated, and I would like to analyze it, to present it to you here. This case and what we're discussing here, proportionality, is not a case about Article 7 of the Charter or about Article 8. It's a case about permissible limitations, about Article 52, paragraph 1 of the Charter, which allows for permissible limitations to the exercise of some rights, and in this case, to permissible limitations to Article 7 and 8, so on the basis of Article 52.1, under the prism, attention, because we're talking about the UNs, of essential equivalence, which clearly, Chris has already said it, and during our last CPD panel last year, we discussed it extensively. Essential equivalence is clearly a standard which is lower than identical. So, as a matter of fact, if you read the Article 52, paragraph 1 that you can see in the slide here, I highlighted the 5 elements. Any limitation on the exercise of the rights and freedoms recognized by the Charter must be provided for by law, respect the essence of those rights, and subject to the principle of proportionality. Limitations may only be made if they are necessary and genuinely meet objectives of general interest of the Union. In reality, as a matter of fact, the best tool that we could use is, I want to break down Article 52.1 to see that in reality what we call proportionality is 5 different elements. And in order to do this, I just use the work that has been done, the great work that has been done by the EDPS a few years ago, in their necessity and proportionality toolkits that I highly advise you to read, where they try to take all the case law of the Court of Justice and the European Court of Human Rights and explain what it is about. And as a matter of fact, you see that we have 5 different elements in reality behind what we call proportionality. It's that to be lawful, any limitation to rights under Article 52, paragraph 1 must be provided for by law, respect the essence of the rights, meet objectives of general interests recognized by the Union or the need to protect the rights and freedoms of others, and must be necessary and proportional. So 5 elements. Of course, I will not be able to discuss all of them here, but I would like just to say that when we read Schrems, there is, I think that the Schrems II decision, I give the quote here, I don't have the time to present it, conflates the principle of legality and the principle of necessity and proportionality. It's not the first time, as Nora has written, this is also the case for other courts, but as a matter of fact, clearly there is a mix between the two and a very ambiguous language to which now I would like to turn in part. So let me first ask the question, this is my second point, in the DPF case, and we know that it has been done with an executive order, does it meet what has been done with this executive order of President Biden, meet the requirements of provided for by law, the first condition that I talked to you about? First of all, I was so much intrigued by this expression used by Schrems II, must itself define. So where did they found this? And I did a lot of research about this, and I found out that, as a matter of fact, this comes from the PNR case, where, of course, in the PNR case, it should have been the PNR agreement itself that should have defined. But if you see the previous case law of the court and all the others, there is absolutely no requirement that the safeguards must be introduced by the same text. The safeguards can be introduced by different legal acts than the ones authorizing the interference. So the court was wrong in Schrems II to use the case the word much itself defined. The second point, of course, is activists said that while only a statute could, as a matter of fact, be considered as law under European standards, I'm sorry, but respectfully, I disagree. I think that an executive order can meet the standards. It's very clear in the case law of the European Court of Human Rights that it interprets law in a substantive, not formal sense, and this is the case also for the Court of Justice of the European Union. There are several cases, including one, for instance, where they recognize that the degree of the French Minister for Health and Sports and enactments of low-ranking statutes can be considered as law for the needs of Article 52, paragraph 1. So it's clear that the executive order can meet this standard. And the third question, of course, there are several qualitative requirements, but I don't have the time to analyze them. But the most important is that this, even if it's an administrative act, an executive, it must be binding. There is absolutely no doubt about the fact that the executive order is binding upon all the members of the US intelligence and the president himself for several issues. So I will leave this behind. There are other issues, foreseeability, accessibility. I cannot discuss them here. To come to my third point for the last, which is a very important point, and which concerns, as I told you, I just picked 3 issues in order precisely to show you that we need some thinking on this. We must not have immediately reject everything, throw the water of the bath with the baby, isn't it? We must think about these issues, and I would like to give you an example concerning the legitimate objectives. And as a matter of fact, what I ask myself reading the executive order is, could this meet the different, you know that the executive order fixed 12 legitimate objectives for surveillance. It narrowed very much the permissible legitimate objective which existed before, and at the same time it created a much more important list of things which are prohibited objectives. I will not discuss all this. I was just wondering, reading these objectives, if it is too broad for European standards. And I read this first. This is the first legitimate objective. I said, oh, Houston, we have a problem here. This was my first reaction, as a matter of fact, because it's written, as a matter of fact, as you can see here in this legitimate objective, that surveillance is authorized, SIGINT is authorized in order understanding or assessing the capabilities, intentions, or activities of a foreign government, a foreign military, a faction of foreign nation, a foreign-based political organization. You can see it behind. And I said to myself, just a second, most of the legitimate objectives link the possibility of surveillance to the existence of a specific threat for the national security of the United States. While here, there is no specific threat of the national security of the United States. I said to myself, Houston, we have a problem because, as a matter of fact, this first legitimate objective seems to permit what we call affirmative foreign intelligence information, which is that, you know, we're going to go and do SIGINT more generally, even if there is no threat for the national security of the United States. So I said, the court might strike it down. And then I started thinking. And I said to myself, just a second. First of all, it makes sense. This is the law of the United States now, the EU. So it makes sense to speak in general terms, high-level terms, in order to provide for legitimate purposes for the United States, because otherwise it will not be authorized. If it's not there, it will not be. I said to myself, if we don't have this legitimate objective, how the US intelligence agencies will be able to do SIGINT with Russian officials to tell us that they are ready to attack Ukraine in February 2022, to inform Ukraine about the fact that this specific attack is mounted and in order to help them defend and to help, and we know that intelligence by the United States and other nations has been absolutely fundamental in order to permit the Ukrainians, especially during the first months, to resist. If you don't have this legitimate objective, it's entirely impossible. 1 minute. It is entirely impossible to do so. So, of course, there was no specific threat to the national security. It was not the US that would be invaded by Russia. The aggression took place against Ukraine. But if you don't have this, it will not be possible to do SIGINT. So this is why I entirely agree with Chris that we must have an approach and to do some thinking about these issues. Of course, there are plenty of things in Central for Advica. The court said that it's undisputed that the impending Sinhal's intelligence regime pursues legitimate aims in the interest of national security by supporting Swedish foreign defense and security policy. So we have plenty of things in the case law which supports also the legitimacy of such a legitimate objective. And my final thing is that, as a matter of fact, let's compare also with others. No activist ever questioned the South Korean adequacy decision. But if you read it, you will see that the Korean law refers to rather broad terms to things such as, to authorize surveillance, such as anti-Korean or anti-national activities. And as a matter of fact, the EDPB said it's extremely difficult to understand what this means. It's extremely broad. Still, the EDPB approved the South Korean adequacy decision. So if you approve somehow the anti-Korean, the Korean law, which refers to possibility of surveillance for anti-national or anti-Korean activities, I think that this is much broader than what you see here below. Just 3 things. There are many other extremely important things, but I just wanted to focus on this to send the message that we must think about these issues, not just adopt a black or white attitude. Thank you.
Thank you very much, Theodore. We'll pass the floor to Nora immediately. Could we have the slides for presentation 2, please?
So, good afternoon, everyone. It is such a pleasure to be here, and my thanks also to Peter for coordinating this really excellent panel. You should know that for these slides, there is no generative ChatGPT effects. We're going to be quite traditional, quite doctrinal. But to make up for that, and because I can't see my slides from this position, I'm actually going to join the floor, and then Chris can interrupt me as soon as necessary.
Wow. Notes like a talk show host. Yeah.
Start asking everybody questions. Can everyone hear me? I know.
No, there's the mic is for online.
Oh, okay.
Yeah.
Oh, because we're on, like, yes. Okay. So, just as Theodore pointed out, we have 8 to 10 minutes for our presentations. So we've decided to focus on some very particular points because we have so many issues to cover in terms of this particular very interesting debate. But of course, please raise any other issues with us afterwards. For me, in terms of the proportionality questions, I've been focusing on the role of the ECHR and how those standards have been influential in the adequacy process. So specifically, how they've manifested in the safeguards and standards provided under the Executive Order 14086. Of course, we're talking about the access and use of personal data from public authorities. We all know that the data privacy framework is much broader than that. So, of course, we're very much focusing on this one specific area of the adequacy agreement. And then I'm looking specifically now at the influence of the ECHR standards, and then also particularly 2 judgments by the European Court of Human Rights Grand Chamber in 2021, which dealt with bulk interception regimes. So we all know that this is the 3rd adequacy decision to be issued by the European Commission under GDPR Article 45. It's also very clear from the relevant documentation that the standards of the European Court of Human Rights, and particularly the judgments by the Grand Chamber in Big Brother Watch and Centrum för Rättvisa versus Sweden, have also played quite influential roles. On both sides, They've played an influential role in terms of the advice that the European Data Protection Supervisor and European Data Protection Board has issued to the European Commission and the other institutions on its assessment of the DPF. And also, it's clearly influenced as well the safeguards and standards that we see under the executive order. And also we see influence of the approach and standards of the Strasbourg Court also in the Commission's adequacy assessment. So just to give some specific examples of this influence, in the European Data Protection Board opinion, we see the board drawing often and quite frequently and at length from the jurisprudence of the European Court of Human Rights. And it does explain why it engages more in this particular respect, because since the Schrems II ruling, the Court of Justice hasn't dealt precisely with safeguards required for bulk collection. It's focused more on bulk retention, but we know that that's also developed further into access by public authorities as well. But there is a much richer set of jurisprudence within the European Court of Human Rights, dating back to the 1970s. And just to be clear, it's not just Big Brother Watch that's cited by the European Data Protection Board. It also cites other significant landmark judgments, including Class versus Germany from 1979. So the board highlights that the ECHR has issued these important decisions, and that's why it's relevant to their consideration of that assessment. But what we also need to consider as well, and I feel a little bit guilty right now because we have this buddy system on the panel, but I feel, partnerships are stronger when there's also challenge involved. So I would just like to say to Theodore very quickly in terms of the legality standards that the Court of Justice is well within its rights under the EU Charter, under Article 51.3, to raise the standards that have been set by the Strasbourg Court. But this also refers back to Theodore's point and Chris's point as well, that when it comes to a third country looking in on Europe and our standards for bulk interception, it's a mess. We have very clear divergences between both courts and both legal orders. So you can see third countries, and you can see the US grappling with this in its adequacy decisions. So in terms of how the European Data Protection Board has tried to straddle this difficult line where we have significant divergences between the courts in terms of how strict limits should be placed on bulk interception, the board highlights in its opinion that the Strasbourg Court, in its Grand Chamber judgment of Big Brother Watch, it does the same in Centrum für Rechtsweise, that while judicial authorization is an important safeguard against arbitrariness, it's not a necessary requirement. But however, when it comes to bulk interception regimes, and this is quite significant because for the Strasbourg Court, strictly speaking, there are no mandatory red lines for the Strasbourg Court. There are for the Court of Justice. It has minimum safeguards that it stipulates under its proportionality assessment under Article 52, as Theodore mentioned. So the fact that we have the European Court of Human Rights in the Big Brother Watch judgment, Grand Chamber judgment, really stressing the significance of ex-ante prior authorization being independent, that is a very significant landmark for the European Court of Human Rights. It highlights the fact that the United Kingdom was lacking this particular safeguard in its previous framework, and it went so far, very robustly, to describe it as a fundamental deficiency, and also that the United Kingdom was lacking the cornerstone of Article ACHR compliance. So by analogy, that would indicate that any other framework outside of the EU would also be deficient in that fundamental way if it was lacking ex-ante independent authorization. And unfortunately for the DPF, it is lacking this fundamental cornerstone safeguard under Article ECHR. And while Theodore has rightly pointed out that there are many different requirements and safeguards that fall under the proportionality assessment, this is the one area where we have a clear consensus between both of the courts, both the Strasbourg Court and the Court of Justice, which is a very rare development. So the other way in which we've seen the influence of the European Court of Human Rights' standards in its case law on bulk interception regimes, as opposed to the case law of the Court of Justice, as I mentioned, is that for the Court of Justice, for proportionality and for data transfers, as we saw in Schrems and Schrems II, Opinion 115, and as we'll see in Schrems III also, it's a question of strictly necessary safeguards or assessing the legal order of another country as a whole, so a holistic approach, as Chris mentioned earlier on. So these are two different approaches. One is much more general and deferential. One is very prescriptive and sets a very high bar. So we see for the Commission, in its adequacy decision for the US, or the most recent one, it mentions in several instances in its recitals that the Commission agrees that on the whole, the safeguards have been met in terms of oversight and proportionality for access by public authorities in the US. And it mentions it more than once. It stresses as well that it's permitted to do this within the parameters of Schrems I and Schrems II. Very interestingly, it uses language and an approach that is completely alien to the Court of Justice. The Court of Justice has never taken a holistic approach. It's never made a reference to assessing any legal order as a whole. This very much comes from the case law of the European Court of Human Rights and Big Brother Watch and Zentrum für Rechtsweise. So as we see here in its conclusion in the adequacy assessment, the Commission notes that taken as a whole, the oversight mechanisms and redress avenues in the US law enable infringements of data protection rules to be identified and punished in practice, and offer legal remedies to the data subject to obtain access to personal data relating to him and her, and the rectification and the erasure of that data. So this is very much the opposite of the approach that we've seen in the Court of Justice, where there are very prescriptive, strictly necessary safeguards. So this is a very, very clear piece of evidence of the case law of the European Court of Human Rights exercising considerable influence over the European Data Protection Board's approach to data transfers in this space, and also the European Commission. So, as we see here, this is the Grand Chamber judgment in Big Brother Watch, where this is the language, thank you very much, where we see it cited that the court considers, when viewed as a whole, the particular set of provisions that were then governing the interception of communications. This was during the post-Snowden era. The UK have since replaced this legal framework. But the law at the time was the Regulation of Investigatory Powers Act in 2000. So even though it highlighted a number of very robust safeguards in terms of redress and oversight, the European Court of Human Rights still held that there was a violation of the right to private life, because we didn't have end-to-end safeguards due to, there were two other areas, but the most significant one was the lack of ex-ante prior independent authorization. And this is from the court that takes a much more deferential and general approach to national security and gives a very wide margin of appreciation to member states. In stark contrast to this, just very quickly, this has been the approach of the Court of Justice of the EU, pardon me. So in La Quadrature du Net, we see very clearly here that for the requirement of proportionality to be met, the legislation must lay down clear and precise rules governing the scope and application. And this goes back to the very important point raised by Theodore regarding the hugely broad scope of what falls within the legitimate objectives identified under the executive order. That is very much a reflection of the scope that's permitted under the Strasbourg case law, but under the case law of the Court of Justice, very strict limitations are put on very specific areas of national security for bulk retention and access. This goes far beyond clear and precise rules, and I've left this part out at the end, but the threshold for there being clear and precise rules in legally binding legislation is even higher when automated processing is being undertaken. And I think it is highly likely that pattern analysis and other very powerful machine learning and data-driven analytical tools are being applied, like intelligence agencies such as the NSA. Pardon me. So just very quickly, because I think I've gone beyond just a minute there. So for collections of signals intelligence, which is another phrase also used in the Swedish case in Centrum för Rättsväsen in terms of the assessment of what we have under the executive order, we have a test in terms of drawing from the principles under the executive order, which in no way mirrors the necessity and proportionality principles under the Court of Justice's case law, but not only the Court of Justice's case law, but also the proportionality case law of the European Court of Human Rights. So to have that much divergence is quite troubling in terms of the data protection privacy framework. And not only that, we clearly see from the collection of signals intelligence that this is not a strictly necessary test, because we very clearly explicitly see that signals intelligence doesn't have to be the only sole means available for whatever legitimate aim is being deployed in a particular instance. So we are diverging far from the Court of Justice's standards within the executive order. There's no question, and the European Data Protection Board has been very clear in its criticism of this, and so is the European Parliament in its resolution. So just to sum up very, very quickly, there is a clear issue with the lack of an ex-ante independent authorization mechanism in the legal framework. That is where both of the courts quite exceptionally converge, so it is quite striking that there's been no effort made in the latest legal framework to address this issue in terms of public authorities' access. This is a fundamental safeguard, that both courts recognize. So again, it is quite striking that it would be missing. And yes, any other questions, I'm sure we'd be delighted to talk more in the Q&A section in the end. Thank you.
Oh, thank you.
I'm going to do the same thing.
All right. Well, can I just...
Sure, absolutely.
Could you put the next slide on, please? Would you park any questions you have now on proportionality? Because we're going to do the next two speakers on redress, and then we're going to open it up for questions. So there we are, difference of view between our first two speakers. Peter.
Thank you. Hi, everybody. And I found Nora, some of your points were very new to me, and I have a feeling people who've worked on this really need to consider what you've said a lot. So thank you for that. I'm going to talk about redress. As soon as I learn how to press a button. Oh, there you go. Okay, so again, I've selected a few points out of longer points that I've written about, some of it with Theodore Christakis. I'm going to talk about some U.S. Constitution-based constraints with recent U.S. Supreme Court cases. My assumption is that the U.S. should follow its Supreme Court also. And we'll talk about standing in federal courts. We'll talk about the independence of the Data Protection Review Court. And some of these points were done in more detail in a webinar last year with Professor Drexler. KU Leuven was the place where we did that. You can find it on my website and other places. And then I'll talk about neither confirm nor deny, which is the very limited answer that the court gives to the data. Yes, there we go. My point here is I bolded the word difficult. It's difficult to draft a redress proposal under this pretty reasonable criteria. It should be lawful for the EU and it should be lawful for the US. And just without reading all the words here, with Ken Propp, a former State Department lawyer, I wrote a proposal soon after the Schrems decision, and Chris Doxey wrote a response explaining why it was a terrible idea and wrong, and so we scrapped that. Then I went and testified in the US Senate and had another proposal, and that got scrapped because it only would work for 702 surveillance, not for Executive Order 12333 surveillance. We couldn't fit Executive Order 12333 surveillance, the international collection, and so that got scrapped. And then with Theodore and talking to the commission, to the US DOJ, to other experts, we spent over a year trying to come up with something that maybe would be lawful in both places. And then Theodore and Ken Propp and I wrote a couple of articles in the European Law Blog. The executive order, in many respects, tracked that. And then the EDPB, notably, really was much more of a green light on redress than probably most people would have expected. And in terms of predicting the Court of Justice, this is a time where the EDPB had condemned Privacy Shield, but has approved, at least for redress, significantly the redress approach here for data protection framework. So here's a slide. I'm actually curious in more discussion afterwards with anybody what other European lawyers think here, So are US constitutional constraints, things limited by the US Constitution, are they relevant to the data privacy framework? Should it matter to the court? If it requires something under the charter, that would violate the US Constitution, right? If it requires this and the US can only do this, is that a problem? Now, I suggest that should be a problem, or at least something to really pause on before it decides the US Constitution is simply not good enough. It's unprecedented if they do this. As far as I can tell, there's been no previous case where the Court of Justice found another country's constitution to be lacking. And also, if you think of things like comity or respect for an ally, for another democracy that's had a constitution for a long time, you'd think that just as the US has had to learn a lot about fundamental rights in the EU might have some reason to learn about constitutional constraints in the US. Now, if you don't agree with that, and the answer is no, then what happens? Well, you could say, let's go amend the US Constitution. And I did empirical research, and since 1789, there have been exactly 15 amendments to the US Constitution. It's really, really hard to pass a constitutional amendment in the United States. And being told by foreign countries to pass a constitutional amendment is not the best first step towards getting agreement on all this. Well, if it's unconstitutional in the US, what's required by the court, then no legislation in the EU required by the charter, and no legislation in the US can make transfers to the US lawful. That's something worth noticing. So that's a reason to go back to this idea of essential equivalence in ways that protect the essence of the right, and to have closer to the as a whole approach, because otherwise, literally, we don't have a way to fix it on redress that anybody's been able to propose. First constitutional problem for the DPF. Article 47 wants an independent and impartial tribunal. Critique has been there should be US federal courts, the federal district judges and appeals judges. We want real judges, Article 3 judges. However, the constitutional constraint is our Supreme Court in cases that I disagree with. I really dislike this doctrine. It is our Supreme Court. So that's worth noticing. The US government has to follow it. The Supreme Court has held that there must be a very clear standing of injury in fact, and in a recent case, the TransUnion case, the mere fact that somebody made a mistake in processing personal data wasn't injury in fact. There has to be additional showing of harm to be able to get to federal court. And even a violation of the statute, it violated a Federal Trade Commission statute, even the legislature couldn't create a right. It had to be a real injury in fact in the view of the Supreme Court. I hate this case too. Sorry, it's the US constitutional requirement. So given this, literally, we can't get to federal court. If you think that's absolutely essential, then we're up against the constitutional thing. The data privacy framework solution is let's have independent adjudication, but not in article courts, not in the federal courts, because we don't know how to build it in the federal courts and have it comply with US constitutional law. Second thing, independence, which is a really tricky, hard problem. Article 47 requires an independent and impartial tribunal. The word's tribunal, not court. The critique of the DPF, which is in the SEPS report that came out this week, which Laura's made in other conversations, critique is this new data protection review court is not independent, whatever it is that independent means. Now, sorry, I've got another recent US Supreme Court decision on point that we have to look at, or at least the US government has to look at. In this Arthrex case, there was a statute passed by Congress. They created patent judges to make decisions about patents. And the patent office couldn't control them, and the Secretary of Commerce couldn't control them. And the US Supreme Court said, this structure of independence inside the executive branch is unconstitutional. This statute was struck down because the independence in this form was not constitutional when Congress did it. Sorry, I don't like the decision, it's the Supreme Court. Now, the executive branch decision, the Supreme Court said recently in 2021, has to have recourse to what? Doesn't sound independent to me, to a politically accountable official. It's a democracy. The president or somebody under the president has to have a role here. So there's a puzzle that we all spent 2 years trying to figure out. How do you create an independent tribunal that also has to have recourse to a politically accountable official? How do you square the circle? How do you not just like give up at this point? So the data protection framework has an answer. We have some officials, the US President, the US Attorney General, who voluntarily relinquish some of their power and put it in a box over here where they couldn't touch it. That's like what you do in a contract when you say, I promise not to do X. The Attorney General and the President have promised not to do X, and it's legally binding that they've promised not to do X. Okay, does that work or not? Let's see, let's talk some more. So we just said that they're giving up some of their discretion and power. The Attorney General issued a real legal regulation. It's in the law, it's public, everybody can look at it. A regulation is like secondary legislation, it's established by law. And the Attorney General gave up his discretionary power to this new court. The President, in his executive order, gave up his discretionary power and told the other agencies to follow the court. Obviously, they can take back their power. Tomorrow, the regulation can be repealed, but so can every law. And if it's repealed, the EU will have notice. The EU cancels this adequacy decision. That should be really clear. Now, will this weird structure work? Well, fortunately, we have 2 Supreme Court cases at least that say, yes, it works. In the famous US versus Nixon during Watergate, the Department of Justice wrote a regulation. The Attorney General gave up some of his power, giving powers to this independent prosecutor. And then who objected to it? Some pretty important people. The Attorney General and the President objected to the subpoena. Supreme Court said, the reg wins. They upheld the subpoena. Attorney General loses, President loses, so long as the regulation stays in effect. So the AG couldn't go and repeal it just by, I don't like this decision. And in that case, they relied on an earlier case called Accardi. There's another regulation by the Attorney General. Gave power to immigration judges, important cases affecting your immigration status. The AG, after the reg happened, didn't like a deportation decision. He wanted to deport somebody, the court said they shouldn't be deported. Supreme Court looked at it and they said, this is really simple. We upheld the regulation. While the law's in place, the Attorney General can't overrule it. Go change the reg, but while the reg's in place, it is lawful and it's the decision of the immigration court that wins. So the data, how am I doing? 1 minute, 2 minutes? 2 minutes. Great. Data privacy framework answer is, yes, there's independence and no executive official can overrule it. I'm gonna do 2 minutes on this new stuff on neither confirm nor deny. The other critique, another critique is each redress complaint receives the same answer every single time. There's either no violation or it's been fixed. And I'm gonna very briefly do these things. You may or may not think under European law, the fact that the member states do the same thing doesn't turn out to be relevant for third states because now it's part of the procedures after Schrems. But all the member states say neither confirm nor deny. They say you have to protect your sources and methods of safeguards, of intelligence, and you have an overall process that protects the person. Another thing is, if you think this is the reason why all data transfers have to stop forever to the United States, well, there's been almost 0 complaints, none yet under DPF. US officials are asking for complaints. We probably have somebody from the US government here today who will ask you again, please make complaints so we can show you the process works. And perhaps that never tried concern is not enough to cut off all transfers forever to the US. But that's not legal. The legal thing, and we're gonna work on more, I'm doing research with Alice Portnoy here, a European lawyer on this, is maybe the real question is the data subject should get access, but only subject to the rules that exist in general for classified information. The European courts are cautious about declassifying data. Joe Kanataki, who had been with the UN, is basically sets up a legal standard that we would follow. And the point here is there's answers in the DPF about why the classification system is good. And the last point I'll make, which is something new that people haven't heard, is the last bullet point on this page. That under US law for classification, there's a duty on officials, including this new court, to seek and get declassification if it was done wrong, if the declassification was unlawful. So if somebody's covering up something, then it's supposed to get fixed by the Data Protection Court. It's a different law, but that at least means that there would be more disclosure if it turns out something was going wrong in the legal system. So I had to do that part way too quickly, but that's my last slide. Thank you.
Thank you. We'll we'll pass the floor to Laura immediately. Could we have the fourth set of slides, please?
Which button is it? Green. Ah, yeah. All right, I will stay seated because I'm tired, but you can all see me walking later. I only, wait, the green button, this green.
Yeah, it took me a minute too.
There are two green buttons. So I only have 2 points that I want to make to keep this light and airy. One, I want to kind of redirect the discussion a bit, because whenever we talk about the data privacy framework, we immediately go to governmental access and immediately go to intelligence access to data. Well, there's a lot of other areas of the framework, and there's also a whole point about redress just for normal people in normal situation when their data goes to US companies that I think should also be talked about a bit. And then second, of course, I have one point that I picked up about judicial redress when it comes to governmental access that is nicely also the last point that Peter mentioned, so it will be a nice connection. The fact that you will not really get any answer from this new redress mechanism that we have established now. To the first thing, so essential equivalence is much broader than governmental access. It's the idea that protection should travel with the data wherever it goes, and that does not only include protection from governmental authorities accessing it, but just all the protection that we have in Europe for our data should to a certain extent go with the data if it goes abroad. And that also includes, of course, that there should be a redress mechanism. I read the data privacy framework several times, and each time I'm very confused about what redress options individuals, normal individuals who are not data protection experts, actually have now when it comes to organizations that are certified under the data privacy framework. I came up with these 6 yesterday, but then I read the EDPB opinion. Apparently there are 7, so I obviously missed one. But those are the ones that I could kind of see. I will spare you the details on each and every one of them, but a lot of them do not always apply, have to kind of be chosen. It has to be published in the privacy policy. So there's a lot of what-ifs. And I think it's very confusing for an individual to understand where can I go if I have a complaint about what's happening with an organization that is certified under the privacy framework. They have to tell you, but if that's your main source, that the person you want to complain against has to tell you how to complain, then I'm a bit skeptic that that's going to work. I'm not making up that there has to be a redress mechanism. This is something that is established for a while. The Article 29 Working Party has confirmed this in the adequacy referential, so where they give guidance to the Commission about what should be in an adequacy decision. And they're quite clear there needs to be a good redress for normal transfers also, and that needs to be ideally administrative and judicial, and also the judicial component I'm not quite seeing in the United States. And I think Peter mentioned that there might be a standing issue. And there must also be something that can really lead to the independent investigation of complaints. And a lot of the mechanisms now are a bit, they even described like this with May, it could happen that the authority will look into this, but there's no guarantee. So there's a lot of uncertainty. This part of the DPF also doesn't convince me, and I'm glad I finally could say this once in a forum. Go to another part that does not convince me about the data privacy framework. And this is now linked to the question of governmental access in the context of national security, because there's also a whole bit about law enforcement, but I think that's less problematic. How does the redress work? I think it has already been mentioned a bit. So basically there is these 3 kind of steps. First, as an individual in the EU, you're supposed to go to your data protection authority. They then channel your complaint via the EDPB secretariat to this office of the Director of National Intelligence, and there it's the civil liberties and privacy officers who will look at it. They can make binding decisions, yay, but they will not tell you what they did. So you as an individual will not know, you will get this neither confirm nor deny response, you will not understand what actually has happened. And then you don't understand what actually has happened, but you have the option to appeal, which I already find puzzling, because if you don't know what they have decided, why would you appeal? If you appeal, you end up in front of this data protection review court, who again, binding decisions, great, but they will not tell you what they have done. Why is it so important that they tell you what you have done? Now we come to my favorite paragraph of the Schrems judgment, paragraph 95, which says, if you don't have a remedy to have access, rectification, or erasure to personal data, there's a problem with the essence of the fundamental right to judicial protection of the Charter. So I think here is one of these cases that links to what Nora said, where the Court of Justice is going further than the European Court of Human Rights did, and where it adds to the protection. It doesn't have to be any judicial remedy, it has to be a remedy with access, rectification, or erasure. And for me, and they said this not once but twice, and for me, access, I don't see it. I don't see how you can get access if you only ever get this standard response. And I agree, declassification is maybe eventually an option, but from what I understood about declassification, there's a problem of overclassifying information at the moment. There's a lot of information classified. There's a backlog for declassification. There will always be a time lapse between you entering your remedy and you getting any information. And then also, I always try to think, how would I explain this to a person that's not in the data protection world? So how would I explain them they should use this remedy? So it was said, it's never used before, it doesn't surprise me. Why would you use it? Like, it's quite some things you have to prepare. We have now some documents of the EDPB, what you have to prepare. Like, you have to you don't have to prove that there was access, but you have to know what data could have been transferred, who was it. You have to provide these details. You have to provide a template. You have to go to your DPA. This all costs you time. And then you will never get an answer. So why would you spend the time, and we all have better things to do maybe, and get this remedy going? So I think that is really a flaw that I see in the framework as it currently is. And I mean, I'm open for declassification to be an answer, but I'm not sure it is. And that would be my 2 points.
Thank you very much, Laura. Members of the panel have had great opportunity to talk. There's obviously a difference of views. Maybe if there's time at the end, I'll ask them if they'd like to comment on each other. But I think it's time for you guys to ask your questions. Does anybody have a question? At the back. Do you need a... Oh, thank you.
Baron Soka, Tech Freedom. Peter, you and I have talked about this, but listening to your presentation, I find your argument quite compelling, but I'm also interested to hear your thoughts on what you and I have discussed about the other aspect of agency independence, which is the Federal Trade Commission. The adequacy determination rests on the independence of the Federal Trade Commission as the commercial guarantor of data protection. So if that's necessary, and you may not think that it is, but if it is, do you think that the solution that you've proposed here might work in that context? In other words, to explain for everyone else in the audience here, the Supreme Court, as you've noted here, the decisions you cited are part of a series of decisions in which the court has steadily rolled back protections, removal protections, for what are considered to be independent agencies or boards in the United States. And it's widely expected, I think you and I agree about this, that the Supreme Court is soon going to overrule the 1935 decision in Humphrey's Executor, in which the removal protection provisions for commissioners on the Federal Trade Commission was upheld. And if that happens, that would mean that provision would no longer have effect, and the president would be able to remove directly Federal Trade Commissioners. And then the question is, what could the U.S. constitutionally do about it? I think you would agree that there wouldn't be anything directly that could be done, but maybe your indirect solution could work. And it makes me think, this is what occurred to me during your presentation, that there's been a lot of talk among Republicans about consolidating the functions of the Federal Trade Commission, which has overlapping jurisdiction on antitrust, with the Department of Justice. No one's really talking about a world without Humphrey's Executor and what would happen to the Federal Trade Commission. But you maybe outline one approach, which is maybe the FTC
by executive order.
Could be governed in some sense by executive order, or in some sense could become part of the Department of Justice. So I'm curious to hear what you think could be done.
First of all, Baron, as you and I just, this is a specialty topic for really arcane American lawyers, and I'm going to try to make it so it's understandable to everyone else. When I was a student, I published a note in the Yale Law Journal about Humphrey's executor, the case he did, so I've been way down this rabbit hole for years. There's two answers. First answer is adequacy is going to be based on today's law. As of today, the FTC is independent. So I don't think that the CJEU has to say maybe there'll be some weird new decision by the Supreme Court. Secondly, if there's a weird new decision by the Supreme Court that I disagree with, if that happens, then what you're suggesting is the president could issue an executive order where the president says that he or she would not fire the FTC commissioners except for cause. And that would be within the president's right, and I think that actually is a solution that maps to the solution we have in the data privacy framework. So there might be an answer to recreate independence by executive order. And I don't think anyone's published that, so if you get it out today, you can be the first one to suggest that.
Well, the problem is Trump wouldn't do it.
Well, I mean, if the problem's Trump, the problem's Trump, and we sure can't solve that today.
And on that happy note, are there any other questions? Anything? Here we go.
And my name is Debray Kennedy Mayo. I'm at Georgia Tech. I work directly with Peter Swire. This is not a question towards Peter. So this is a question towards the other people on the panel. And I am generally trying to find out if this exists. So there has been discussion of the neither confirm nor deny, and there's a concern there. And Peter pointed out that certainly even if member states give a similar response, that doesn't solve the problem for the U.S. I understand that. What I am curious is, related to what the Schrems case says, related to the access to the data, the rectification or erasure, is there a current country, whether it's in the EU or outside of the EU, that handles this in such a way that it would comply with that requirement? So, I mean, whatever the country is, if it's Japan, is there a model out there that the U.S. could at least look at for how the response is given back to individuals in a redress situation? So there could be some real discussion. So are there any models, or is this really something that the U.S. with the EU's response back is going to really have to create that would be then perhaps a model for the rest of the third countries that are out there?
Yeah, I can try to respond. So I think the problem with neither confirm nor deny is also there's a complete lack of any nuance. So we are indeed also in Europe allowing restrictions to information and to access, but these always have to be carefully calibrated, case-by-case basis, balancing different factors, and it's not a blanket, always it's going to be neither confirm nor deny, no information. And I think that's the biggest issue, and there are countries that do it better, at least I hope. Remembering the Korean adequacy decision that was mentioned today, if I remember correctly, actually their governmental access, at least as how it's described in the adequacy decision of the Commission, actually it seems like they would get information and they would be more like having this access certification and erasure elements, at least to a larger extent than it's now possible under the DPF. But of course, there has to be I think the problem really right now is that there is no nuance at all, and I would accept that a regime where there is the possibility on a case-by-case basis to sometimes give information when it's possible, when it's no longer like harming the investigation, etc., that could actually work for the CJEU. But at the current state, this is not the system that's in the DPF. It's really, or actually in the executive order, it's really, yeah, you will never get information. Maybe in 5 years when it's declassified, but I'm not sure that will ever happen.
I could just follow up very quickly on access to classified information. I mean, I must say, given the limited amount of access that an individual within the EU has regarding a national security matter, I find it simply astounding that we'd be having a conversation about declassifying information and an individual within Europe getting access to that within a third country, mainly because the strict controls on what national security agencies do within Europe is very high. It's very high even if you're the European Court of Human Rights, even if you're the Court of Justice. Both courts have specifically asked member states for evidence as to the effectiveness of particular bulk retention powers, and they have been very flatly denied. So we are in a very interesting juxtaposition then in terms of within the proportionality debate that we're having as to where that leaves courts in general if they don't even get access to how these particular regimes are operating. And just on a related note, in the Grand Chamber judgment in 2021 concerning the signal intelligence legislation in Sweden, it wasn't a point that the court engaged upon at length, but it was stressed by the NGO, by the applicants in that case, that even though on the statute, on paper, individuals are meant to be notified and should have access if they have been affected by one of these programs, none had actually ever been issued, no record. So there's a very important distinction between the rights that are being guaranteed within the European human rights legal orders, and then what's actually happening in terms of public authorities within each member state. And just to follow up very quickly on, I think it was Theodore's point earlier on, and also Peter's, it is still true that the Court of Justice is still holding third countries to a higher standard than member states. It's now holding member states to a much higher standard than ever before because national security isn't explicitly part of EU treaty law, and that's a very controversial development. People will still tell you that national security doesn't fall within EU law, but the Court of Justice says something differently. But for us, for this immediate conversation, the bottom line is that the Court of Justice is holding third countries to a higher standard than its own member states.
It's 29 minutes past 6. I would like you now, you've been thinking, what is the Court of Justice going to do with this? You remember the 3 questions. I'd like you to do a show of hands vote on now what you think. You've heard this, that we've got standards. We don't necessarily respect them here in Europe. And we've got to find a system that works for exports. So the 3 questions are, is the court going to say, job done, it's not perfect, but we'll accept it? Is it going to say, well, we have doubts about certain aspects, proportionality, for example, but we'll see how it works out in practice? Or is it just going to say, sorry, try again? What do you think should happen? Could I have votes, please, for what was the first one? Job done,
Don't
acceptable.
overrule the commission.
Yeah. Does anybody think that the court should say, you know, this is not perfect, but we will let it through?
Oh, just very quickly, a quick clarification. There's a difference between what you think the court should do and what the court will do.
We should vote on both.
Yeah, well, maybe you just vote on what you would do. But am I still getting no hands for that one? Okay. Oh, here we
There are some.
Yeah,
They're afraid, you know.
We had
the
talked in
European
our
audience.
prep panel that a secret vote might get a different outcome than having to raise your hand and saying the U.S. is okay. So it's a little hard to vote in public.
And not to knock that right back, but just because you think the court might uphold the data privacy framework would not mean that you don't have issues or you don't think there are issues with the data privacy framework. These are 2 very different questions.
Every time we vote, it's difficult. Things must be clear.
Okay.
Many lawyers in this room, I think they appreciate the clarification.
Of course.
That's right.
So this is a very lively panel. Second question, who thinks that the court will say, we have doubts about this, we're not sure? And there are different ways the court could do it. It could simply say in its judgment, we're not sure about this, that, and the other. And it could just leave it hanging. For example, there's a direct action. It could leave it hanging until Max Schrems gets an action to the Court of Justice, and then we'll be able to see how it pans out. Or it could say temporal effects to the judgment, and it could say we are not absolutely wild about the way proportionality is defined or the way it could work. What about the president changing and suddenly getting rid of it all? So we will defer we'll say this is valid, but these points must be put right within a year. Anybody who thinks the court would like to go that way? Oh, this is wonderful. There's two people who think this. Okay, so third question, who thinks the court should simply say, no thanks, try again?
Didn't work very well.
Wow. So it looks to me as if the abstentions have it.
Certainly in front of
We haven't had the bell yet. So I would like to ask a question, which is about the proportionality and points that were made. What about the point about the fact that the president, in secret, could change the list of objectives? That's a pretty powerful worry. Does anybody on the panel have a view about how to deal? Well, yes, okay.
Yes, when I read this in the executive order, I was really, I said to myself, it's unbelievable. They put the 12 legitimate objectives, and then suddenly they introduce a thing saying that the president could secretly add a new legitimate objective, and without even the European Union knowing. So I said to myself, this is the perfect thing for the court to strike down and I said this immediately to all my to all my US colleagues. As a matter of fact, of course it's possible. I think that this could be, but it could be easily fixed also. They can amend the executive order and just erase this thing. Now, are you going to block data transfers and everything for this? I was just thinking, I did a little bit more of research, and I said, after my initial shock, I said that probably we should not exaggerate the importance of this provision. The objective does not seem to be to create a tool for abuse, but in order, to mislead the European Union and to add secretly objectives, but rather to ensure that the EU will not tie the executive hands. I think that this was something that it was very important for the intelligence agencies. I read again Kennedy versus the United Kingdom in 2010, and it is written there that by the nature of things, threats to national security may vary in character and may be unanticipated or difficult to define in advance. Similar considerations apply to the use of the term in the context of secret surveillance. So if we follow what the court said in Kennedy, then it could make some sense not to tie entirely the hands with specific legitimate objectives. And I would like to say, of course, it's perfectly possible for the court, but then they will have to undo the UK adequacy decision also, because if you read, as a matter of fact, the Investigatory Powers Act, you will see that interception, SIGINT is allowed for national security purposes, defined in general, without all these 12 things that we find in the EU, for the purpose of preventing or detecting serious crime, or in the interest of the economic well-being of the United Kingdom, so far as those interests are also relevant to the interest of national security. Imagine if the Americans had put this in the EU, everybody would have cried wolf. As a matter of fact, I read an opinion by Brown and Korf, who said that the list of operational purposes for SIGINT in the United Kingdom, and you can tell me if they are wrong, is not public. So we don't even have these 12 legitimate objectives, plus all the prohibited legitimate objectives. So, of course, we can enter into this logic. I think, personally, I have a big issue with this, but I think that, on the other hand, that we should think, once again, not adopt a dogmatic approach, try to establish eventually some trust between the two. Let's not forget that the European union states largely benefit from national security inputs by the United States, including in the context of things like threats from Russia and other hostile powers. So eventually there is a way to strike down the adequacy decision for these specific purposes, for instance, but you could also adopt another approach and say, well, if we start undoing on this basis, we will undo also the UK, we can undo the UK adequacy decision where this will end. So I think, once again, it depends on what kind of stance the judges will take.
So I've said this point to U.S. government officials and said, I don't understand why this is going to survive. And I welcome the U.S. government articulating why they think it's lawful, because I don't have a defense for it.
I'll follow up very quickly to say that for the Strasbourg court, it is going in one very different direction from the Court of Justice. So, as I mentioned earlier on, in the Le Quadrature du Net judgment, the Grand Chamber for the Court of Justice established a hierarchy for national security and established that there had to be threats to national security to warrant bulk retention of communications data. And that was hugely significant because that is a world apart from the approach of the European Court of Human Rights, from Kennedy versus the United Kingdom, to much more recently in the Grand Chamber judgments in 2021, in both Big Brother Watch and in the case against Sweden. The court expanded beyond national security and held that bulk interception regimes could be adopted not just for national security, so already taking that broader scope, but also for the essential interests of the state. So here again, we see these very significant divergences in terms of the scope of national security and what is permitted. And then just another very quick clarification, because Chris previously raised this in a pre-meeting that we had, in terms of whether the Court of Justice itself was becoming more deferential in terms of bulk retention with regard to a recent case concerning copyright law. And this was with regard to the retention and access to bulk collection of data identifying the civil identity of an individual, or otherwise referred to as subscriber data. But it's very important to remember, because people have been stressing this, that this could perhaps mean very significant implications for the next adequacy decision for Schrems III. We're talking about signals intelligence with the data privacy framework, which is intercepting everything, which is content and related communications data. The data that you're talking about in terms of subscriber data, it's still very significant, and when combined and aggregated with other data sets can reveal an awful lot about an individual, but it is only one of a whole very rich set of metadata that can be accessed by public authorities. So to say that the Court of Justice is beginning to be less strict, I would argue would be misguided. I would say that the court's actually taking quite a proportionate response and saying that, well, access, even in bulk, to data identifying civil identity or subscriber data, it is less intrusive than the bulk interception of content and all the related location data and traffic data that goes with that. And I think that's actually something that should be welcomed, because it's a more nuanced approach by the Court of Justice.
Just a short. There's a lot of signals intelligence that's not bulk collection. So under Section 702, it has to be targeted at individuals who are outside of the United States and non-U.S. persons. And there's specific selectors for specific email addresses or phone numbers that are used for 702 orders. It's not as though everything gets vacuumed up. And so I've written at length on this in prior testimony. There's many parts of the U.S. system that are not bulk collection under any reasonable view of the word bulk.
Can I swing this back to the opening comments, which is, we've gone into detail now about the DPF and its good points and its bad points. But what remains is that if you want to ship data out of the EU, if you're a small company, a medium size, whatever, you have to do the same assessment as the European Commission, and you have to say, okay, United States, Korea, whatever, I have to be satisfied under the EEG, the European Essential Guarantees by the board, I have to be satisfied that the country receiving it, even if it's got an adequacy ruling, even if I've got a contract with the exporter, I've got to be satisfied that that country's constitution is going to mean that government access will be done in a legal way from our point of view under the EU Charter. What I don't, and this is just a huge burden on our own data exporters. What I don't understand is why isn't somebody doing something about it? You've got the US, you've got the Commission with this agreement. Why are they not trying to do something to have an initiative to deal with this at international level? Because finally, are we going to have a situation where you just can't export data legally? We really have to find a solution for this. We can talk about all the problems, but if we can't make an agreement with the United States with its own constitution. So can I just ask the panel, why is it, do you think, that nobody is doing anything about the more general problem?
I don't think that it's like, on the contrary, I see that there is huge interest on this question. There are a lot of welcome developments. I had the privilege here with Thorsten, who is back to serve as external experts and counsels for the OECD process, which was extremely important. And we had the OECD Declaration on Government Access to Data held by the private sector. Of course, this is just the beginning, because this was the objective was to find the denominator in all the systems of the OECD member states. But we have seen other things, the GPA, the General Privacy Assembly resolution, and there is a huge interest. It's not like people don't care about this, but I think that in the context of adequacy decisions, we have requirements which go far beyond the OECD process, and it is, if you see the G7 states, they all have adequacy decisions, so at this stage at least, and probably this would be a more appropriate forum instead of having all the countries. Recently, the European Union, you know that they made the first conference of all the adequacy partners. So there is a lot of interest, there are a lot of things to build. There are at the same time some counterwinds. We're seeing the United States, for instance, recently, and Peter has written about it, adopt some decisions which are a little bit, seem to be a little bit striking in relation with a traditional approach of free flow of data, including the TikTok ban, as a matter of fact. We could discuss about this endlessly.
I don't think we have time today.
Yeah, we don't have the time today. But I think that there are things to be done, and what is extremely important also will be the EU-US agreement on access to e-evidence. There's a huge opportunity to create trust by by removing precisely the conflicts of laws, which will need some consensus from both parties, and especially from the United States. I think it's extremely important to address this issue, but because if you address this issue, you create trust. It's all a matter of trust. If you trust the Data Protection Review Court, if you trust the P Club, they will examine, they will not get, the P Club will not receive a neither confirm nor deny response. They will examine all the elements. You have independent people who will receive everything to see if there's a problem. Okay. So I think it's a matter of trust.
Yeah, and I think we're coming to the end. Did you want to actually add anything, Lara?
I'll keep it for the reception.
Okay. Well, thank you very much for coming.